As we've been covering today, a federal grand jury indicted former President Trump on Tuesday, alleging that he was a participant in a criminal conspiracy to try to subvert the results of the 2020 presidential election, to which he falsely claimed to have won during and after and before the January 6 attacks at the Capitol.
Here to discuss the indictment is lawyer and author of Get Trump, Professor Alan Dershowitz. Welcome back.
Well, thank you.
All right, so before we get into some of the kind of political implications of this indictment, I want to ask you, from a purely legal perspective, what you think the most difficult part of this indictment is going to be for Donald Trump.
I think it's going to be to prove or to raise doubts about whether the government can prove his actual state of mind. If the government can prove that he knew that the election was fair and that it wasn't stolen, and that he corruptly and dishonestly and with an intent to be corrupt went forward with his plans, then they'll win the case. But if they can't prove beyond a reasonable doubt his state of mind at the time of these acts, they will lose the case. They may win it at trial because it's the District of Columbia, which is the most overwhelmingly anti-Trump district in the country, but they will probably lose it on appeal.
That's super interesting because it reminds me of the documents case where there was a similar issue, but we do have this recording where Donald Trump says, I know this is not a classified document and I can't, this is a classified document, I shouldn't have it and I can't classify it at this juncture, right? So that is a bit of the red herring. I'm sorry?
That's absolutely right. They have a smoking gun in that case. Now, the case itself isn't nearly as serious, possession of classified material, as this trying to distort the election. But here they don't seem to have a smoking gun, a gun, or any smoke at all. They seem to have lots of people who are prepared to testify, who will testify. Donald Trump actually believed that the election was stolen. He was wrong. He was dead wrong. But the Supreme Court of the United States has held repeatedly, there's no such thing as a false opinion under the First Amendment. If he had the opinion that he had won the election, then the corruption allegations can't stand. So that's the hardest thing for the prosecution. The hardest thing for the defendant, of course, is at the trials in the District of Columbia. And he's going to try to move it, obviously, to Virginia or somewhere else where he can get a more purple jury rather than a jury that's so overwhelmingly anti-Trump.
Just to follow up, though, I want to ask you what that kind of a smoking gun would look like, because there are these moments of the indictment in which there is an allegation that either the defendant, some of his co-conspirators, or both were made aware that certain claims of election fraud in various states were false by people that are close to them, or because they had a lawsuit to try to find more votes and they actually found that they had lost by more than they thought they had lost by initially. You know, various facts coming forward where people are corroborating the idea that there was no election fraud and that he legitimately lost in these various states. Is it the case that that is insufficient? And if that is insufficient, what kind of smoking gun, other than Donald Trump in an email saying, I know I have lost, but we're going to keep fighting this, would actually result in him losing?
Well, you'd have to have circumstantial evidence that he actually believed he lost. It doesn't have to be a statement from his own mouth, although that would be the strongest thing. That happened, of course, in the Florida case, where he said, I could have declassified this, but I didn't. It's still secret. That's a smoking gun. There is no comparable smoking gun as far as we know here. I know they tried to get it from Jared Kushner. People expected that when he was called in front of the grand jury, he would say, well, my father-in-law told me he lost. But he said the opposite. And people I know who've spoken to Donald Trump at about that same period of time all say with virtual unanimity that he had talked himself into it, that he believed it. So the issue will be, what if he believed it, actually believed it subjectively, but his belief wasn't reasonable? Is it enough to prove that it was unreasonable, that everybody told him he was wrong? I surely said he was wrong over and over again on television and in my writings, and people much, much closer to him said he was wrong. But is that enough to satisfy the corrupt intent standard? I think the answer to that is no. This is too speculative an indictment. Thomas Jefferson once put it very colorfully when he said that in order to have a valid criminal statute, it has to be so clear that the average person would understand that if he read it while running In other words, the image is he has the book in front of him, he's reading it, he's running, and he doesn't understand it. Well, I have read this indictment while sitting, and I find a lot of problems. It's very creative, it's very speculative, but the ex post facto clause of the Constitution requires that the law be absolutely clear at the time the crime was allegedly committed. And these creative statutes, particularly the last one, the Civil War statute, denying people their right to vote. And remember, too, there's another issue in the case. They claim he deceived people. Well, this indictment is, I read it. I didn't read it as carefully as I would have if I had more time. But as far as I can tell, when it paraphrases or quotes the speech he made on January 6th, it apparently leaves out the most important words, the words that he told his followers to protest peacefully and patriotically. If in fact the indictment leaves that out, it is about as fraudulent as anything that is alleged against Donald Trump. How can you do that? How can you leave those out? It was left out of the January 6th hearings, the committee hearings. They actually did worse. They doctored the tape. They edited the tape to leave out those words. You know, if you're going to charge a person with deceptive statements and false statements, you can't have an indictment that is also deceptive and false.
Right. And the fact that so much of this, goes into the statements, I mean, that's the kind of free speech concern that people are raising. Does this indictment, touch on would you have a concern that if this is to move forward and if Trump was convicted for all these things, it would lend itself toward the violation of our rights to engage in political speech, notwithstanding the actions he also took, to follow through on what might have been a sincere wrong belief on his part that he won the election?
No, I think that's right. I think that it really makes it a crime to lie to the American people about politics. And if it were a crime to lie to the American people about politics, Congress would have to conduct its business from Alcatraz prison. It's part of what
you're persuading me of this, Alan. Stop.
Well, what about lying not to the American public, but to the various state elected officials who he was telling, or members of his team, the co-conspirators, were saying there's been evidence of election fraud. They would come back to him and say there was not evidence of election fraud. We can't find any evidence of election fraud. I understand that the speech arguments have to do a lot with his public statements and the alleged kind of incitement on 1/6, but I find that much less compelling than the idea that he knowingly was attempting to mislead state election officials who had the actual ability to overturn the Democratic election results in favor of Trump's victory, which was not substantiated by the actual voting tolls. Is that a distinction there worth observing?
Well, it's a good point. I mean, there is a difference between just exaggerating or lying to the American public and telling potential electors statements that are false. But again, they have to prove that he knew they were false. And that will really turn on whether they can break it down. I mean, they're not going to be able to prove beyond a reasonable doubt that he didn't think the election was stolen. He did think the election was stolen. I'm convinced of that, and I think a jury will be convinced of that. But there are elements of it when he says that the Michigan vote was such, and the evidence is overwhelming that it wasn't, or that the Pennsylvania vote was such. When you get down to specifics, they may be able to prove that he knew that he was stating things to electors or to state officials that he knew, certainly he should have known, were false. But, when you put the state of mind of a defendant on trial, you never know how the jury is going to react to it. I think jurors will come away saying, from what we've seen of Donald Trump, he believed this. He talked himself into it. Maybe it was irrational. Maybe it was wrong. But we're not going to put a potential candidate in prison or a real candidate in prison for what he erroneously believed. Let's remember one more thing, the bottom line. If you're going to indict the man who has 44% poll support against 44% for the incumbent president, it's an actual tie, according to the New York Times polling. If you're going to indict that man and you're the attorney general appointed by the president, you better have the strongest possible case. It can't be a speculative case. Speculative based on the law, speculative based on the facts. It should be a case where the gun is smoking, the fingerprints are there, the confession is obvious, and nobody would doubt it. It should meet the Richard Nixon standard. Everybody believed that Nixon was guilty, including his own party members and his own supporters. That isn't true here. And so I think the standard that must be met to avoid us becoming a banana republic, a republic in which incumbent presidents often indict their political opponents, to avoid that or even the appearance of that, the indictments have to be stronger than they are. So far, the only indictment that's strong is the Florida indictment, but the crime itself is not the kind of crime that should be brought against somebody when they're running for president, much the way it wasn't brought against Hillary Clinton when she was running for president. But the other two cases, the New York case is an absolute joke and scandal. There is nothing there at all. This case is a strong case in the sense that if he did do the things it's alleged he did with the knowledge that it's alleged he had, it's a strong case, but the evidence seems weak. And so it doesn't meet the standard, the Nixon standard, that I think should be met before the chief opponent of the incumbent president is indicted for an election-related crime.
Alan Dershowitz, author of Get Trump, a very timely titled book. Everyone should get a copy of that. Thank you so much for joining us.
Thank you.